Fatimah went to the supermarket and bought 2 cans of sardine with price Rm9. When arrived at home, Fatimah wants to cook the sardine. When she opened the can and poured the sardines into the bowl, she realized that there is a screw in the sardine. She takes a picture as an evidence.
The issue that arises is whether Fatimah is entitled to the damages and who will be liable for the defective product.
Under Section 67, Clause 1, there is a defect in the product if the safety of product is not as expected by the consumer. In assessing the safety of a product, the court will take into account a few circumstances as provided in Section 67, Clause 2 of Consumer Protection. There are 3 types of defect: manufacturing defect, design defect, and failure to warn. The defect of the product in this case fall under the manufacturing defect. A manufacturing defect refers to an error in the design or production of a product causing it to not work properly. The product deviates from its intended design and can cause harm, injury, or fatality to the consumer. The sardine counts as a manufacturing defect because there is a foreign object, which is the screw, that is not supposed to be in the tin. The unintended foreign object in the sardine constitutes an error in the production of the product, and the screw also can cause harm or injury to Fatimah. Therefore, the defect in this case is said to be manufacturing defect.
The law that can be applied in Fatimah's situation is in the Section 32 Clause 2 of CPA 99. The goods is categorizing as an acceptable quality if the goods fit with common purposes expected by the consumers, acceptable in appearance, no defect on the goods, safe and durable for the consumers. Besides that, according to the Section 50 Clause A of CPA 1999, it has been stated that the right to redress has been conferred to the consumer if the implied guarantee in Section 32 of CPA has not been complied by the producer. Lastly, according to the Section 68 Clause 1 Clause A of CPA 99, if there is any damage occurred by the defective product, either wholly or partly upon the consumer, the producer of the product can be held to take responsibility.
As the implied guarantee as to acceptable quality has been breached by the manufacturer, where the sardines that have been supplied are in a defective condition, the consumer has a right to damages. As stated in Section 68(1) of the CPA 1999, the producer or manufacturer will be liable for damages due to the defect of the product. Therefore, Section 68(2) clearly provides that within a reasonable time where the damage occurs, the consumer who suffered the damage may request the suppliers to identify the producer of the product, which in this case was the producer of the sardines. Failure to comply with Section 68(2) will make the supplier liable for the loss or damages to the consumer as stipulated in Section 68(4). However, if the supplier succeeds to identify the producer of the product, it will make the person to liable for the damages is the producer and not the supplier.
The conclusion that can be drawn in this case is that Fatimah, as the buyer, is entitled to damages for the defective product she obtained. The manufacturer, as the producer of the product, will be liable for the damages, and the supplier may also be liable if it failed to identify the manufacturer of the product as per the Product Liability Concept.
That's all from us. Thank you.